Welcome everyone to today's AHLA podcast, where we will be talking about trends related to healthcare fraud settlements. There's a lot we intend to cover in today's podcast related to trends, and also in conjunction with the AHLA's just released Healthcare Fraud Settlement Index. I have a copy of it right here, the second edition, which breaks down different settlements in the market. And it does it in a nice way. And I would encourage anyone listening in to or that are watching the video podcast to look into this. It breaks out different settlements in the market related to the types of fraud allegations. So False Claims Act, Stark Law, anti-kickback statute allegations, and then it also breaks it out by state where the action occurred, and then has an part related to the facilities where the fraud settlement is related to. But I just wanted to touch on that it does tie into today's session. We're not going to go into the weeds on the book itself, but it does highlight the fact that we are able to publish a fraud settlement index. It shows that there is significant movement and activity related to fraud settlements in the market. Lots to cover today. My guest today is Marissel Descalzo from Tache, Bronis and Descalzo. And she and I are going to talk through fraud settlements. A little background, she and I are both licensed in the state of Florida. We're presenting at a conference earlier this year, and when I saw her presenting, I thought, man, we should have her as a guest to talk about fraud settlements. Obviously, there always is lots going on in the state of Florida, and I'm sure she'll be able to provide us with some context on that market, and then more broadly as we think about fraud settlements. Today's video podcast is brought to you by the American Health Law Association's Fraud and Abuse Practice Group. I currently chair the practice group, and our mission is to help our members stay informed about healthcare fraud and abuse and compliance issues. We're just starting a new program year right now, and our vice chairs are eager and are doing a great job of developing webinars, publications, and other content to educate our members. But before we get into the back and forth, Marissel, can you please introduce yourself?
Sure. And first of all, thank you, Joe and AHLA, for having me on this podcast. I'm excited to have this conversation with you today. I am, like you mentioned, I'm from Florida. My office is in Miami, but I actually have a national practice where I focus on white collar criminal defense and the defense of False Claims Act cases. But I specialize in healthcare fraud prosecutions and healthcare fraud defense in the false claims arena. And so I have cases, lots of cases all over the place, but my base is in Miami.
Great. And as I mentioned, I'm Joe Wolfe. I chair the Fraud and Abuse Practice Group for AHLA. I'm a shareholder with Hall Render, and I'm the practice group leader for Hall Render's Health Regulatory Practice Group. And like Marissel, have a very national practice focused on fraud and abuse, Stark Law compliance, provider compensation models, value-based care, all related to healthcare. So we're going to get into a little bit of the trends related to settlements in the fraud and abuse and fraud settlement space. Before that, I just wanted to give just a brief background on what we may mean by healthcare fraud settlements. We're typically talking about claims under the False Claims Act, the Stark Law, the anti-kickback statute, and their state law equivalents. I'm sure many of you listening in, because you're listening to this kind of a podcast, probably have some background on those laws. But the anti-kickback statute is a fraud statute that focuses on healthcare providers potentially exchanging remuneration in exchange for healthcare items or services that are payable under federal healthcare programs. That is an intent-based statute. There are requirements under it relating to whether the conduct was knowing and willful, and so on. And so the relevant inquiry in let's say an anti-kickback statute claim focuses on the subjective intent of the parties. So, I mean, that's the anti-kickback. Stark is a much more technical law. They play in under the False Claims Act. We may get into this, and whether or not a false claim was triggered or predicated by anti-kickback or a Stark law violation. And of course, there's the bread and butter, which is situations related to overbilling, upcoding, and we may get into that as well. But again, the anti-kickback statute and Stark law can serve as the basis for liability under the False Claims Act. And so, that's a bit of high level background on fraud claims, fraud and abuse issues, and what may drive a fraud settlement. And I'm going to get in some back and forth with Marissel, and I'd start by, Marissel, from your vantage point, what often triggers a false claim in your experience?
Well, there's lots of things that can trigger a false claim because so essentially a false claim is, in simple terms, it's when any person submits a claim that they know is false to Medicare for payment. And some typical examples are maybe a physician submits a claim for services that he knows or she knows he did not provide. But then there's other things that can give rise to a false claims violation. You mentioned an AKS violation. So if a claim is premised on a kickback, that can also be rendered a false claim because you have to sign or certify that you are complying with all state and federal laws when you submit any claim to Medicare. If you're violating the AKS, you're not complying with the law. And so that is a trigger as well. So there's lots of things, and it's a highly regulated area, and you really have to, all practitioners need to be careful. Joe, can you tell us what is usually the genesis of a false claim investigation?
Yeah, thanks, Marissel. Every investigation has facts and circumstances that are driving the allegations, and that's something that we always need to think about. If you're working in the compliance department and you're thinking, you're working on a physician contract, for example, understanding the facts and circumstances and how an arrangement may be framed and how defensibility could ultimately be tested and what kind of position you would take to defend that arrangement, I think is a thoughtful and helpful process for anyone from the get-go. An arrangement that triggers an investigation down the road is often brought by a whistleblower. It's someone who is close to the arrangement and identifies issues with it. Maybe they're not heard out once those issues are brought to light, and then eventually become a whistleblower down the road. And so having a thoughtful compliance program that addresses concerns, that focuses on defensibility, that develops a record that supports arrangements that are going to be more defensible down the road are a way to reduce the risk of a false claims investigation down the road. Data outliers can drive this, the government becoming aware of outliers from a coding standpoint, from a billing standpoint. That could be a way that an action may be brought outside of a whistleblower context. You can even have situations where criminal investigations can be launched related to a False Claims Act investigation as well. If your organization is going to be brought into a situation where there may be a false claims investigation and challenge, you may receive a civil investigative demand asking for certain types of document or information from the government as they start to unpack and understand the facts and circumstances. And that process can be very drawn out. But the genesis is usually facts and circumstances, sometimes confusion or individuals who feel like their concerns are not addressed. That's the practical driver of many of these situations. And that's the unique opportunity at the beginning to try to address and reduce the risk of an eventual False Claims Act investigation. Marissel, thinking about whistleblowers, and we do know that many of these investigations begin with whistleblowers. Why do you think they bring these actions? What drives them to reporting and bringing forth allegations in this space?
I think there's two types of whistleblowers. There's the money-driven ones, because it's a huge payday for a whistleblower to bring one of these actions. I mean, it's sometimes it's sufficient money that they can probably retire, more money that they've seen, in all their lives. And so I think money is a big motivator, and it's no secret that is why, the government dangles that carrot of you're going to get some portion of this to bring more people to come forward, because clearly the government can't do all the enforcement on their own. I think there's also another subset of whistleblowers that are do-gooders, physicians, compliance personnel who, feel that healthcare organizations need to be doing the right thing, that practitioners need to be doing the right thing, and they feel either morally motivated or ethically motivated to tell, to right the wrong. And those are more dangerous, I feel, for companies and healthcare providers, because they really, are in there investigating, and they really, have a vested interest when they're not motivated only by money. Joe, you want to tell us, are you seeing a pattern with respect to false claims cases in your area?
Yes, we see some of the consistent cases that we've seen for the past 15 years in particular, focused on physician compensation, provider compensation. In my space, most of my practice is focused on provider compensation issues, Stark and kickback compliance, defensibility in that space. And so we're seeing a continuation of some of the trends that we saw before, which is allegations on the big three that arrangements are exceeding fair market value, that they're not commercially reasonable, and perhaps that they've taken into account referrals. The government has provided a bit more clarity around the legal standards related to those issues, but we're still seeing ongoing allegations related to those arrangements. In some recent cases, we've seen a bit more granularity around issues of fair market value and process around fair market value. And so I do think that that's an area that healthcare organizations should be focused on, how they're going about establishing defensibility around those big three, because they may be subject to more specific and granular challenges on that. The trends beyond that, I think, we've seen more and more discussion of Medicare Advantage enforcement. We're seeing more and more discussion about the future state of physician arrangements and when we may see investigations related to the actions taken during COVID. I do anticipate we'll see in the future trends towards challenges around value-based care as well. But in many instances in my space, when we are seeing civil investigative demands, they're focused on the physician compensation models and challenges to those models as well. And so, I mean, in stepping through that, the pattern is really continuing to fall back to that big three, though. Marissel, in your space, do you have any examples that you wanted to provide of recent enforcement actions that you wanted to touch on?
Sure. And you mentioned Medicare Advantage, and I will say that is a big target area for the Department of Justice. When I'm, going to continuing education courses, and when I'm speaking to my friends at DOJ, they're constantly talking about Medicare Advantage. That's what they're focused on. And so recently, with that theme, Cigna had to settle a case for $172 million. And it was based on their failure to submit or failure to withdraw inaccurate and untruthful diagnosis codes for their Medicare Advantage plan enrollees. And basically, the government alleged that Cigna was engaged in chart review, and that they were paying vendors to go and assess patients at home, and that they were using these assessments to bill falsely without doing any due diligence to make sure that they were accurate. And then falling from that, some individuals were charged as well. But Cigna really got dinged for that. And there's going to be more of that, because it's just it's a money-rich area where the government can recover lots of funds. And Joe, how about you? What recent enforcement actions have you seen on your end?
Yeah, I would agree. I do think, to your point, that managed care is in the crosshairs a bit as we think about Medicare Advantage and managed care generally. And I think you mentioned, that a very, very important case. And, seeing allegations around chart reviews for Medicare Advantage beneficiaries, diagnosis codes, and whether those codes are submitted those types of allegations, I think we're going to continue, to see more of. In looking at the recent, case law and what are things going to look like, I think we're going to continue to see allegations related to the COVID period and steps that were taken during that period. We continue to see the data sort of showing that these False Claims Act claims are on the uptick. And so I do think getting your arms around what actions were taken during the period during COVID, whether you were relying on some type of waiver, that's a good use of time and effort now to make sure you're in a position to get ahead of some of those issues. So, I think we're going to continue to see an uptick in that area. So, Marissel, as you think about 2024, what areas do you see the DOJ targeting? Are there any areas in particular?
Yes, I mean, I already mentioned Medicare Advantage, but and you touched on COVID-19. Anything pandemic related is just the government is finally coming after it. I have one COVID testing site lab case indicted. I have 2 under investigation. There's more, I'm sure, that are going to start getting indicted. The government's still going after the labs and the genetic testing. There's also, anything with prescription drugs, they're still interested in that. And also antitrust violations in the healthcare sphere. We heard about this, a couple of years ago. The government started investigating, allegations that doctors couldn't jump from one place to another. Nurses couldn't, jump from one job to another. There was agreements not to allow this. The government decided that's an antitrust violation, decided that this was going to be an area and a focus of prosecution. The government, frankly, has lost a lot of those cases, but they continue to be interested in it, and it continues to be a focus area. So we're going to see some more of those cases coming, I think, in 2024, keeping that antitrust division busy. And so that's what I'm seeing from my end. Now, Joe, I just talked about 2024. Do you have any insight on what future trends in enforcement could be, especially now that, the Chevron doctrine was overturned? There's the Loper case. Any other things that, from your perspective, are going to be now, places where the government will target?
Yeah, I think we're going to continue to see the trend upward in the data related to the number of claims that are filed. I mean, if you follow that trend line, if I go back to 2022 and the reported data, you talked about, we saw like 2.2 billion in FCA settlements and judgments. Over 1.7 billion of that was related to the healthcare industry. We saw almost $500 million paid to relators. And some of the data I saw, it's 658 qui tam suits filed. An interesting development, 305 of those were non-qui tam suits that were filed as well. So that's an interesting area. Maybe we could see more and more development and less reliance on whistleblowers as the cases grow over time. But then if you look at the 2023 data, we saw a jump from about 2.2 billion to 2.6 billion. Bigger chunk of that was in healthcare. Qui tam suits over 700. So that shows you these continue to grow and snowball. And then 500 non-qui tam suits filed. So this is a trend I think we need to keep our eyes on, just where the enforcement is coming from. But I think we're going to see those numbers continue to rise. I think from a trend standpoint, we're going to continue to see consistent numbers around self-disclosures, because as we mentioned, a lot has happened during the COVID pandemic, and as there's more attention brought to some of these issues that are unfolding, and we saw over the last year, it's a trend I didn't mention, but more focus on advanced practice providers and support provided to physicians through the use of those APPs, and some recent settlements there. I think we're going to see proactive compliance efforts from healthcare organizations to take their issues through the self-disclosure process, because it's definitely a luxury to resolve issues through self-disclosure rather than run the risk of very large damage figures in an eventual enforcement action. So I think we're going to see, from a trend standpoint, more and more self-disclosures going forward. As I mentioned before, managed care, I think, continuing to be in the crosshairs as well. And then with regard to the, kind of the case law development related to Chevron and the overturning of Chevron, I think it's a bit of wait and see as we look at courts and how they're going to interpret agency guidance going forward. What is that going to mean for providers? I've heard some in some webinars talking about the Chevron change that the healthcare organizations should even fall back and understand all of the positions that they've taken, and whether or not they should be, that they may have more leniency in certain areas than they did before, and what that means. On the flip side, I think there could be an opportunity for whistleblowers to bring allegations similarly, where perhaps the actions taken were not in line with the statute, but they were relying more on agency guidance. So I think it's going to be a bit of wait and see as we think about the impact of post Chevron. I just think, we all know that the changes here will be, they will impact healthcare. It's a significant ruling, and it could impact, and likely will impact, the court's method of analysis for determining lawful agency action. And I think the decision was much broader than we anticipated, and its full impact, again, still remains unknown. So we'll have to see how it ultimately plays out. Marissel, from your vantage point, anything new on the horizon that you wanted to tell listeners about?
Well, there's a couple of things. There's a new compliance program criteria, which companies should know about, and it's refined a bit. But I think that the real thing that's on the horizon is the government's new early disclosure program in the healthcare space, and there is really a push to have companies come in and tell on themselves, to kind of self-disclose and tell the government what they did wrong, and put it all out on the table, and there's a reward for it, and the reward is you're going to get less of a fine, and the fine can be up to the discount can be up to 50%, is what we're hearing, depending on how much the government believes the company cooperated. So I think that that's something that is going to continue to evolve. It's Chevron that settlement was the first one. I mean, I'm sorry, not Chevron. Cigna was the first settlement of that type. I think that there's going to be more settlements of that kind in the future, and more people are going to be coming forward. And I know that there are some that are still under wraps that the government's not talking about, but big or small, the government wants you to come in and self-disclose, and they'll reward you for that. At least reward the company. And I think also, parallel investigations continue to be a thing. And what I mean by that is that there's a civil investigation, there's a criminal investigation. They can both be going on at the same time. So, always be careful, because you don't know if it's going to go criminal and you gave up too much information during the civil process. Joe, I mentioned the new compliance program. Is there anything that stands out to you about that new compliance program that you want to tell, that you tell your clients about?
Yeah, and I would encourage anyone listening in to, if you haven't explored it, to take a look at the new general compliance program guidance that was issued by the OIG back in November of 2023. It's a significant document, and I do think it's going to drive compliance, and already is driving compliance activities across healthcare. If you're not familiar with it, it applies to all individuals and entities that are involved in the healthcare industry. And the guidance document talks about key aspects of general compliance risk, compliance infrastructure, and it addresses key federal authorities. For anyone engaged in healthcare business, it reiterates and expands upon the 7 elements of a compliance program. It has in there adaptations for small and large entities, and also discusses compliance considerations and an OIG process and has resources in it. And much of what is in it is not new to healthcare, to the industry, to all of us who've been involved, but it reinforces best practices and recommendations from previous OIG guidance. And so it really becomes, that's why I said it's a significant document. It sort of has everything in there. And so if you're developing a compliance program from scratch, or you're looking at it with fresh eyes, it's a significant document, and one I would look at. And it gets into the weeds about, the compliance officer, the responsibilities, structure and operations and limitations. It talks about the compliance committee, the structure and operations of the compliance committee, and how to set the tone from the top. It gets into that. Discussion about risk assessments. There's discussion about quality and patient safety considerations. And one thing that really jumped out is that the government talked in some length about the fact that compliance programs may differ based on the size of an entity, and that a compliance program for a small entity should be structured so that the entity can gain the benefits and protection of a compliance program within the constraints in which it operates. So there's an acknowledgement that smaller entities may not have the top of the shelf compliance program with all the bells and whistles that another organization has, but it talks about, but then it also says compliance leadership for large entities should be aligned with the size and complexity of the organization, and you should be reviewing the scope and adequacy of your compliance program for those reasons. So if you have a significant organization with significant operations, it is important to think about the size and capabilities of your compliance committee. If you're lean there, that may not look good under the November 2023 guidance. Just one other thought on that compliance guidance is it discussed the increasing number of new entrants into the market, including technology companies and new investors and organizations that provide non-traditional services in healthcare settings, and said, talked about how they may be unfamiliar with the unique regulations and business constraints that are applicable to the healthcare industry, and that they should be taking steps to ensure that they have the understanding of the federal fraud and abuse laws. So you can't put your head in the sand here. If you're a new entrant, the government is saying you have to be on top of this too. And certainly if you're accepting federal healthcare program reimbursement, you're certifying compliance with these laws. And so you need to get your arms around that. And so they're speaking to and I agree, there's a whole new set of innovative players coming into this market, but this guidance is saying they need to be aware of these laws and developing compliance programs as well. So that I can't say enough about that 2023 guidance. And so, from your standpoint, Marissel, I just want to give you a chance to give any final remarks to our audience before we wrap up today. I've really enjoyed the conversation and the perspectives you brought to today's podcast.
Thanks, Joe. I have too. I mean, I think my final remarks are just to touch on the new compliance program. I think it's a warning sign to all these private equity companies coming into the market. They don't have the excuse anymore that they're far removed from healthcare and they don't understand the regulations. I mean, I think that this new program and this new guidance is like, you need to know, you need to make yourself, familiar. We're not giving you a pass anymore. We're already seeing some, private equity enforcement actions. And I think that there's going to be more, just naturally, because private equity really is coming into the space. And so, I want to say that. And the only other thing I'll say is, the disclosure program is not all it's cracked up to be. And I just caution everyone, companies, individuals, before you go in and you decide to cooperate with the government and disclose that you're giving up a lot. You're giving up a lot of rights. They're going to expect they want, they reward information. So if you give up if you waive your attorney-client privilege, even if you don't have to, but they want you to, and they want you to give up text messages and emails, and it really can open up a can of worms. So, but really, if you're going to go down that route, really analyze all the pros and cons, because it can be very dangerous. So thank you again, Joe, for having me.
And Marissel, I'll just echo that. I mean, I think, if you're going to go down the route of self-disclosure and going down the self-disclosure protocol route, to Marissel's point, it's really important that you do that in a thoughtful way. And I would say even making sure you're counseled by someone with experience in that area, because it's really important that you do that rigorous analysis, that you outline, and you're able to describe how you remedied the situation and that it's appropriate going forward and what have you, and that you do that in a way that gives the government confidence that the issues have been dealt with and resolved, because that makes it less likely you're gonna invite more questions when you go about that self-disclosure. So I really appreciate those comments. Well, thanks, Marissel, for participating in this discussion on fraud settlements. Again, check out the AHLA Healthcare Fraud Settlement Index, the second edition. It's a great resource. Thanks to all of you for tuning in, and watch for upcoming content from the American Health Law Association, from the Fraud and Abuse Practice Group, in the form of podcasts and webinars and written materials as well. I encourage you to consider attending the upcoming American Health Law Association Fraud and Compliance Forum. That's in October, from October 28th through 30th. It's in Baltimore, like it is each year. It's a great conference because we do get a number of government participants, because we're there in Baltimore, and you can hear their insights directly from them. It's a premier event from my perspective. And I do encourage anyone listening in or watching to reach out if you'd like to volunteer to be on a future podcast, or just get involved with the Fraud and Abuse Practice Group. We would love to have more and more voices and more involved in trying to unpack some of the trends we're seeing in the industry and bring relevant content to our members and our listeners. So thanks again, Marissel. Thanks to everyone for tuning in, and have a great day.
Thank you.